here at the Cayuga Community Health Network, and that program is our Healthy Neighborhoods program. So everyone should be seeing on their screen, and if you're not, please put it in the chat box if you guys can't see this for whatever reason. You should be seeing our most recent Healthy Neighborhoods program flyer. And so what the Healthy Neighborhoods program is it's a collaboration between our organization, the Cayuga Community Health Network, and the Cayuga Health Department. And we are able to do home health inspections through this grant project. And so what we do, or what we've done in the past, as some of you might be familiar with our program or maybe had a home assessment done in previous years, is that we come into the home, we speak with you can either be an owner of the home or you can also be a tenant. It doesn't matter. We come in, we do a home assessment, we ask you a few questions, we have our trained coaches go through the house, look for any issues. So they're also looking for things like lead paint, if there's any fire hazards, are there enough smoke detectors in the area for each area where they're supposed to be. And so pretty much we go through it, and we also are able through this grant to provide kind of some home safety devices. So the biggest one we do is our free smoke detector and carbon monoxide detectors. We also do radon kits when they're available. We do, if there are young children in the home, we can provide some baby proofing products for the home. We also have a couple, like an asthma kind of packet that we're able to put together, and we do the home lead testing. This year, due to COVID, it is a little bit different, and so we will no longer be going into the house for the home assessments. We're going to be doing them virtually. So you can call, we can FaceTime, we can set it up depending on your needs. And when you reach out to our program coordinator to schedule the home assessment, and then we'll be able to kind of walk through the home with you virtually, see what you might need for PPE supplies, as well as something new that we're doing. You might need a couple smoke detectors, you might need no smoke detectors based on what you kind of already have and what our program coordinator determines, you might be in need of based on the home assessment. It's 100% free. There's no price, anything like that. So if it's something that you guys are interested in, feel free. There's the contact information right here. There's the number, and then there's also an email for our program coordinator who does this. And I also just wanted to take a minute to show you guys the website that we have for our organization. So if anyone's interested in doing it this way as well, because I think it's helpful to see. So let me move my little... You can head right to our website. This is the Cayuga Community Health Network website, which should be sharing on the screen. If it is not, put in the chat box and I will check. Sure. You can go to our programs, our Healthy Neighborhoods program, and it should load here. You guys can see these are old pictures of when we used to go into the homes to do the home assessments. Hopefully that's something we'll be able to restart at some point when it's safe again, but there's a little bit of information on it. And if you're at all interested in signing up for a free home assessment and it's easier for you to fill out this form than call, feel free to head right to our website and you can fill this out. And again, this was right on our home website page. You go to programs and then you can see Healthy Neighborhoods. So if that's something you are interested in, we would love to come out and do a free home assessment and provide anything that we can provide that you guys might be in need of. So I will take this moment now. Why don't we do a little bit of a break, and we will plan on coming back probably around that 10:15, 10:10 time slot. If you guys want to take a break, stretch, get some water, and then we will plan on resuming with our next speaker just around 10:10, 10:15. And if anyone has any questions, we will still be on the Zoom webinar. So if you guys have any questions while we're on our break, feel free to put it in that Q&A box and we will be checking that. And we will see everyone at 10:10.
Welcome back, everyone. Thank you for coming back and joining us for our presentation of the new normal of fair housing. I would like to introduce Sally Santangelo from CNY Fair Housing. Sally, we're just going to have you unmute yourself and go ahead and share your screen for your PowerPoint, and we should be all set.
Okay, thank you so much. Good morning, everyone. Let me just get my screen. Actually, whoever is sharing their screen, there we go, perfect. Let me try that again. Get my right screen up here.
Perfect.
I will go ahead and also just turn on my camera on briefly, just to greet everyone. My name is Sally Santangelo. I'm the Executive Director of CNY Fair Housing. And our organization, we are located in Syracuse, but serve 15 counties of central and upstate New York, including all of Cayuga County. And what we do is we provide fair housing services. So primarily we work to investigate cases of housing discrimination and to provide legal representation to victims of discrimination. We also provide a lot of advocacy, particularly on behalf of individuals with disabilities regarding reasonable accommodations and modifications, but also advocacy around issues like source of income discrimination and other areas. And of course, we do a lot of education and outreach on fair housing rights and responsibilities as well. I will go ahead and turn my camera back off so we can focus on the screen and the presentation. So I'm going to talk this morning about fair housing rights and primarily focus on what kinds of issues we're seeing right now in terms of housing discrimination issues we're seeing and that people may be experiencing during the COVID pandemic. And especially some of the things that we're kind of concerned about as maybe eviction moratoriums and as well in possibly in the winter. Though certainly there's a lot of uncertainty in what's happening and, uncertainty in terms of what's going to be happening with the courts. So we'll talk about eviction moratoriums and some tenants' rights updates towards the end. And try to give, a snapshot of what's happening, though this is a constantly changing area, but I will give the update as it stands currently. So our organization, as I said, slides don't want to advance. There we go. We work to enforce fair housing laws and to stop housing discrimination. And when we are talking about fair housing laws and housing discrimination, we're talking about issues of unfair treatment and discrimination against people based on what we call protected classes. And so these are, there are both federal, state, and local laws that protect people from housing discrimination and unfair treatment in their housing. And again, based on these protected classes. A housing provider can deny somebody housing for a lot of non-discriminatory reasons, like if an individual has a poor rental history, for example. Perhaps they have, caused damage at numerous apartments, previous residents, and they have a number of bad landlord references, for example. What the law does, fair housing laws do, is protect people from discrimination based on these protected characteristics. Under federal law, those protected classes include race, color, national origin, religion, sex, meaning gender, disability, and familial status, which refers to any families with children under the age of 18. New York state law also offers protections for all those same categories under federal law, but in addition, New York state offers protections based on age, marital status, military status, meaning active duty or veteran, sexual orientation, gender identity, and source of income. Now, I'll talk more in detail about source of income because it is an issue we're seeing a lot of right now. But primarily, source of income refers to the receipt of any kind of housing assistance. Oh, having issues with my sound. Is that better if I speak up? Sarah, do you want to just pop in and tell me if you can hear me okay?
We can hear you okay. Sarah had to step out for a moment, but I'm hearing everything just fine.
Okay, I will try to speak up. I've had some issues with my microphone. I thought I had fixed it, but it seems to want to come back sometimes. So I will work to speak up. Thank you. If there's continues to be issues, please let me know in the chat or the Q&A, and I can switch to my phone audio if I have to. Okay. So as I said, source of income refers to the receipt of generally of any type of housing assistance to pay rent, whether that's Section 8 or public assistance. And I'll talk a little bit more about that in detail. In terms of who and what types of properties are covered by fair housing laws, fair housing laws really apply to just about everybody involved in housing, which can include the landlords themselves or their staff, maintenance staff, leasing agents, or management companies, as well as real estate agents and brokers, the owners of the property, even if it's different than the manager, as well as corporate entities like homeowners insurance companies and mortgage lenders. Even local and state governments are also subject to fair housing laws in some circumstances, and I'll talk a little bit about that briefly as well. Almost all types of housing are covered in New York State, are covered by fair housing laws. The only exemptions in New York State is any housing is owner occupied two-family houses. So if you have a two-family house, a duplex, where the owner lives in one half and rents out the other half, then that is exempt from fair housing laws. However, those two-family houses, two-family owner-occupied houses are never exempt from race and color protections. And again, it's only two-family houses where the owner lives in the property. There may be certain circumstances where properties are allowed to have age-restricted senior housing, but those senior housing properties have to follow the rules of the of senior housing rules. Under fair housing laws, there are specific practices that are prohibited, both in federal and state law. So a landlord cannot, on the basis of one of those protected classes, cannot refuse to rent or sell an apartment or a home. And we do sometimes see outright refusals to rent, and sometimes even housing providers who will tell a tenant that they won't rent to them because of their protected characteristics. We see this sometimes based on disability or based on familial status. So families with children who are being told that they won't rent, landlord telling them they won't rent based on the fact that they have children. More often, what we see are more subtle differences, like a landlord lying about the availability of housing. So a common scenario we see is when a caseworker perhaps will call on behalf of a tenant with a disability, and the landlord will tell the caseworker that the apartment is not available, yet they continue to advertise the property. Or perhaps the caseworker will have a coworker call without identifying where they're calling from, and suddenly the apartment is available. Or perhaps a housing provider can identify a person's race or ethnicity based on their speech pattern or their name, and they state that the property is not available. Another way we see more subtle differences is that is prohibited under the law is housing providers steering people to certain areas of a building or to different buildings to segregate populations. And this could be maybe steering a family with children from a second floor apartment to a first floor apartment, or maybe having separate areas of an apartment complex for families, for example, or for seniors. Other prohibited conduct includes setting less favorable terms and conditions for people based on those protected classes or protected characteristics, such as charging higher rent or differences in the application process or requirements for living in the property. This is something we see pretty often, where a individual may be told different things about what the application process is, such as what the background checks are for the property or what the credit requirements are, again, based on those protected characteristics. We've had, for example, a case we investigated a couple of years ago where we had we do undercover testing to verify what's happening in the housing market. And our tester, we had a Black tester who was told that they needed to provide pay stubs and be subjected to a criminal background and credit check in order to rent a property. And yet a white tester, a white applicant that was looking at that apartment was not told they needed to provide pay stubs and have a background and credit check. And these kinds of differences often are undetected by people. So if you were to go, ask about an apartment and a landlord tells you that that you need to provide a driver's license for criminal background check or credit check or provide pay stubs, more than likely you're going to look at that and say, okay, well, that's the requirement, right? And a lot of times people don't even realize that that requirement is only being applied to them because of that protected characteristic. In that case that we were investigating, it was race, but it could be national origin, it could be disability or other protected categories. Applying the property rules differently because of a protected status is another example of setting less favorable terms and conditions, and would also be considered illegal conduct. These types of cases can be harder to investigate because we can't, with an application process, we can have somebody go to the property to inquire about renting and find out what the application process is. We can't do the same thing to see how the property rules are applied after somebody has moved in. But we sometimes see instances, for example, where we have families with children who are being evicted due to noise violations, for example, where adults are not being evicted or not being given noise violations for similar levels of noise. Or we see, and this has happened in a number of cases, we see Black children at an apartment complex who are being given lease violations for behavior that is tolerated of white children. And those families with the Black children of those Black households are being given lease violations or threatened with eviction when their children are engaging in the exact same behavior as other children. Or we may, just another note, we may see different rules based on disability. So for example, we've seen cases where individuals with disabilities are told that they can't have visitors at a property, for example, or can't congregate in certain areas of the property while others are being allowed to. Discriminatory advertising is also a violation of the law. It's illegal to post any type of ad or advertisement or statement that indicates a preference, a limitation, or a discrimination based on those protected characteristics. Normally, they are not as obvious as this ad, but they are more subtle differences, such as ads we see that say perfect for single or couple. That would indicate a preference for families without children, or working people only, or clean, quiet professionals preferred. These are all actual ads that we've seen in our work, and all properties that we found to discriminate against various protected classes, often families with children or people with disabilities. And this could be any type of ad, whether it's on Craigslist, a Facebook ad, or even a sign in the window of the apartment itself. One area where we see a lot of discriminatory advertising still is with source of income discrimination. So source of income was added as a protected class in New York State in 2019, in April of 2019. And the law states that an individual can't be denied housing based on where their lawful source of income comes from. So if somebody pays rent with a Section 8 voucher or public assistance or DSS payment, they cannot be denied housing or treated differently because of that source of their income. It also includes income such as SSI, SSD, child support, income maintenance or alimony payments, and it also includes security deposit agreements that are given to tenants by their Department of Social Services to help a tenant pay a security deposit, or TRA agreements. Every county kind of calls them something different, but a security deposit agreement is covered under source of income protections. So a landlord has to accept that security deposit agreement as a source of income to pay the security deposit for that property. Another way in which we've been seeing this law violated is the way in which landlords are calculating income requirements for tenants. And this is probably the number one type of issue we've been seeing over the last 6 or 8 months, where we have landlords who have basically are saying that they're following the source of income laws, yet what they're doing is they're creating an income requirement that is so high. So an income requirement stating that the tenant has to have 3 times the total rent amount in order to rent the apartment. However, if you had 3 times the total rent amount, you wouldn't actually qualify for the housing assistance or the voucher that you're using to pay the rent. So it is a way to effectively eliminate anyone with a voucher or assistance from being actually renting that property. So a landlord, if they're going to have an income requirement, has to base that income requirement on the tenant's share of the rent. So if, for example, you have a property that rents for, say, $1,000 a month, and a tenant has a voucher that pays $800 and they pay $200, then the landlord's income requirement should be 3 times the tenant's portion, or so $600. And best practice on this, when looking at income requirements, is actually that a landlord, particularly for somebody with a voucher, with a Section 8 voucher, a landlord doesn't actually even need to do an income calculation, because the housing authority has already done the calculation. The housing authority has already determined how much rent a tenant can pay. So the housing authority, or whoever is issuing the voucher, they've already determined how much the rent the tenant's paying. So the landlord really shouldn't even be doing a calculation of that income, because it's already been done. Another way in which landlords are doing these income restrictions, is they're not counting the voucher income or the assistance in the same way as they're counting other types of income. So if you're facing any of these issues, you're calling about an apartment, or you're trying to rent with any type of housing assistance or other lawful source of income, and a landlord seems to be giving you the runaround or is outright denying you, you can give us a call, and our information, we'll make sure everyone has it, and I know Sarah certainly will. But we will, excuse me, we're always available to look into those issues further and further investigate those. Okay, as I mentioned, familial status is another area where we see a decent amount of cases and discriminatory practices. And so familial status refers to any families with children under the age of 18. It also includes pregnant women and anyone who has or is trying to obtain custody of minor children, such as a grandparent who's getting custody of a grandchild. And a landlord can limit, one of the ways in which we see these familial status cases play out is with families being told that they have too many kids for a particular apartment. And we see this a lot. We see landlords who will state that somebody has too many kids, but which they can limit, a landlord can limit the number of people that live in an apartment, but it has to be based on the size of the apartment. And that doesn't just mean the number of bedrooms, it means the size of the bedrooms that are there. So if a landlord says, so a strict policy of, for example, of 2 people per bedroom may actually be a violation, a fair housing violation. Instead, a landlord has to look at what the size of the bedrooms are to determine how many people can live in each of those bedrooms. And so very small bedrooms could be limited to 1 person. Large bedrooms could have 3 people. Every municipality sets their own standard on what the actual square footage has to be. So I'm not sharing that here, but the local codes office can determine that or can identify what the standards are. And if you ever have questions on this or being told that you have too many kids for an apartment, then you can contact us. Also, children under 2 do not count when determining the number of people per bedroom. As I mentioned earlier, that we're seeing cases or seeing instances where families with children are also having the property rules applied differently to them. This has been a concern, particularly with the pandemic, as children and families are stuck in their homes. It'll I'm sure be an issue this winter as kids aren't able to go outside and play, and inevitably they're going to be inside. They're going to have energy to burn, and if they're in an apartment, they still need to, burn that energy. And kids do make some noise. I have 3 of them. I know that they make some noise. And a housing provider has to, allow some noise by children, particularly when it's, not during quiet hours. So if this is an issue you're facing where you're being told that your kids are making too much noise, we may be able to help advocate on your behalf in those circumstances, provided that it is reasonable. I have, as I said, 3 kids, 2 of them make a reasonable amount of noise. One of them would maybe be a little more challenging in an apartment, but it has to be, again, a reasonable amount. Another big area of concern, particularly related in the last, during the pandemic, as people are struggling to pay rent or are isolated in their homes, has been harassment. And, nationally, there's been an uptick in harassment cases. In housing related harassment cases. So there are 2 types of harassment under fair housing laws. The first is quid pro quo harassment, and this involves a request or demand for sex or sexual favors in exchange for housing or any kind of housing services. Housing services could be not just the ability to rent, but it could be maintenance on the property. It could be forgiveness of back rent, which is why it's a real concern right now during the pandemic, as people are struggling to pay rent due to job loss, that we're concerned that landlords may be offering tenants or demanding tenants engage in sexual acts in order to forgive that back rent. And even important to note that even if a tenant acquiesces in those demands, it is still harassment. And I think a lot of times, particularly when it's related to back rent, a lot of times I think tenants feel like they've lost their rights because they have because they were behind in rent. So there's a certain shame or sense that maybe they've got themselves into that situation. There is no circumstance in which a landlord should be sexually harassing their tenants, even if the tenant owes them rent. They don't owe them anything else. Hostile living environment is the other type of harassment that we see. And this is where there is conduct that is severe or pervasive that creates a hostile living environment for the tenant, again, based on one of those protected characteristics. That could include sexual harassment or gender-based harassment, such as displaying lewd photos or making inappropriate comments, even when there is no exchange request or quid pro quo request. But it also can include other types of harassment based on race, national origin, sexual orientation, disability. And the harassment does not have to include physical contact. It doesn't require physical contact. It can just be written or verbal conduct as well. And also under the law, individuals are protected from harassment, not just by the landlord themselves, but also by their staff and by other neighbors. Particularly, so if you have a neighbor who lives in the same building or same complex or same property that is owned, or lives in a property that is owned by the same landlord, the landlord has an obligation to act to protect their tenant from harassment by another tenant when that harassment is related to their protected class. Now, there may be instances where two tenants just don't get along, but we're talking about instances where it is really one-sided harassment, where somebody is being harassed by another tenant. A landlord has an obligation to act to work to protect that tenant's rights. Okay, another area of the law that is protected is related to individuals with a criminal record or justice involvement. And there's a couple different ways in which the law protects individuals. First, there's protections in New York State that make it illegal for a landlord to deny someone the ability to rent if they have, based on an arrest record alone. So an arrest without any kind of conviction is not a legitimate basis to deny somebody housing. And in addition, any kind of a blanket ban on individuals with a criminal record are considered discriminatory. So just an outright ban by a landlord saying that they won't rent to anyone with a criminal record would be considered discriminatory. Even an outright ban on anyone with a felony conviction would be considered discriminatory. Instead, a housing provider has to conduct an individualized assessment that looks at these three factors that are identified here. What is the nature and the severity of the offense that occurred? How long has it been since the person was convicted? And what has the person's behavior been in the intervening time? So if somebody has a youthful offense or perhaps a nonviolent drug offense, and they've been it's been a while since their conviction and they're back in the community, then the housing provider should be renting to that individual. And if they're going to deny people based on that criminal background, they have to be able to show that they have a substantial legitimate, non-discriminatory reason for denying that person. Another area that is protected, even though it is not written into the law as one of those protected characteristics or classes, is still protected by the way in which the law is applied, is related to domestic violence. So domestic violence survivors are protected under both fair housing laws as well as other state laws in New York. A housing provider cannot evict a survivor of domestic violence because of incidents or police activity that are occurring at the property. Local governments cannot require that a landlord evict domestic violence victims because of police activity, what are called nuisance ordinances. So if a local government has an ordinance that says a landlord has to evict tenants that they considered problematic because of repeated police activity, that ordinance has to have an exception for domestic violence. No victim of a crime should be evicted because they are a victim of a crime, and that includes domestic violence. Also, if a housing provider does have a housing provider can ban the perpetrator or evict the perpetrator, but they shouldn't put it on the tenant, on the domestic violence survivor, to enforce that that ban because it does put that person at risk. In addition, domestic violence survivors that live in subsidized properties have rights under the Violence Against Women's Act as well, or VAWA, and that includes the right to an emergency transfer, the ability to self-certify that they are a survivor of domestic violence as opposed to needing an order of protection. They can just self-certify in order to gain those rights. Also in those VAWA covered properties, which is any type of subsidized property, an individual can't be denied housing due to the effects of past abuse, including things like a poor credit history or poor rental history that is a result of past abuse. Okay, disability discrimination is, again, another area where we see a lot of cases. Disability has traditionally been about 50 to 60% of our cases, both in central New York as well as nationally. Disability accounts for the majority of fair housing cases. And we see disability cases in a couple of ways, and I'll talk about reasonable accommodations and modifications in a moment. One area where we see is, as I said, housing providers denying people based on the fact that they have a disability, and a housing provider cannot refuse to rent or sell to a tenant based on their disability. They also, another thing we see a lot is housing providers who ask tenants extensive and intrusive questions about their disability, such as asking things about, we've heard landlords who ask a tenant or ask a family member who's looking for housing on behalf of a person with a disability, things like what's wrong with them, or asking a person if they can live independently, or stating that they need to talk to that tenant's doctor to find out more about their disability, or asking about medications or treatments. All of those would be considered inappropriate and questions to ask. In addition, a housing provider has to provide equal access and opportunity for people with disabilities to use and enjoy the housing. That does not mean a housing provider has to make every unit accessible. What it does mean, though, is they have to allow for reasonable accommodations and modifications for that individual to give them access and opportunity to use that housing. So what does that mean? So an accommodation is a reasonable accommodation is a change, exception, or adjustment in the normal rules, policies, practices, or services offered by a housing provider that allows someone with a disability to use and enjoy the dwelling and related facilities, to allow them the full use and enjoyment. Some common examples we see include assistance animals in no pet housing, assigned parking spaces when parking is normally first come, first serve, perhaps transferring units because of a disability related need, changes in communication methods or changes in trash pickup procedures, snow removal. And this last one, leniency for behavior that violates a lease. This has been another area of concern that we have in the last, during the course of this pandemic, is sometimes an individual may have behavior that is related to their disability, but that is a lease violation. We've seen instances, for example, where we had a tenant who had night terrors and was a veteran with post-traumatic stress and brain injury. And they had night terrors and would scream at night. And it was a noise violation. It was actually waking up neighbors, and it was clearly a noise violation, but also it was beyond that individual's control, and it was related to their disability. So we worked to get some leniency for that behavior, and then worked to address the needs of the housing provider to provide for quiet enjoyment of other tenants. Ultimately, we're able to move that tenant to a different unit and help insulate and soundproof their bedroom, to try to reduce the impact on others as well. The issue of concern we have right now is related to things like hoarding disorders. So particularly as individuals are in their homes more and in their homes without visitors, particularly, vulnerable, as individuals are in their homes and maybe don't have family members that check in on them coming by, or they don't have maybe their regular aide coming by to check in on them, or maybe it was a Meals on Wheels worker that would come once a week and pop in and at least check how they're doing. As people are losing those connections, we're concerned about the conditions that might be developing in people's homes that may struggle with maintaining their units or have hoarding disorders. And so we may be needing to seek leniency for tenants who are struggling with these issues in the coming months. I expect we're going to start seeing more and more of these cases, especially as landlords want to start inspecting units more after, or go into units, or perhaps even re-renting those apartments. And so it's an issue that I expect we're going to see more of in the coming months. And there are ways in which we can help, and we can help connect people to services in order to assist. Another area, another accommodation that we're seeing more often lately that's being requested is for tenants who are at high risk due to COVID, to avoid having, as an accommodation, to avoid having their landlord enter their apartment. And so we have tenants who maybe are due for an inspection, for example, or maybe the landlord is going to rent that apartment out to someone else, or their lease is up and the landlord wants to show the unit. And so we have tenants seeking accommodations to avoid having anyone enter their apartment. And we think that that's a reasonable accommodation to ask for, but we may try to find other ways in which that tenant can show the unit, such as doing a virtual walkthrough, for example, or taking pictures of the apartment to provide the landlord, for example. Reasonable modifications are structural changes, physical changes that again allow a person with disabilities the full use and enjoyment of the housing and their related facilities. Common examples of modifications include ramps, grab bars, sidewalks for somebody with a mobility impairment, maybe needing a sidewalk in a different area, flashing smoke alarms or doorbells. Another one we've been seeing more lately, I have to add this to my examples, is power assisted doors. So particularly for apartment complexes where you have tenants with wheelchairs, especially as wheelchairs are larger, tenants may need a power assisted door to help navigate and get in and out of that building. For reasonable modifications, those physical changes in federally subsidized housing, so this includes any kind of public housing or other HUD subsidized housing, a housing provider, the landlord, is responsible for the cost of all modifications. This does not include if somebody uses a voucher. If somebody has a voucher, then that's considered private housing, even though it is paid for. The voucher is federally subsidized. The housing itself is considered private. In private housing, the tenant is responsible for paying for modifications within their units. So, for example, if they needed grab bars in their bathroom, the tenant would be responsible for that. But the landlord is responsible for paying for some modifications to common areas. So if it is, for example, a entrance to an apartment building, where you have an apartment building that is 10 units and there is a common entrance that is used by everybody, the landlord would be responsible for paying for the modification to, say, the tenant needed a ramp. The landlord would be responsible for paying for that if it was going to be used by everyone or commonly used or could benefit others. If it is a single family house that a tenant is renting and they need a ramp, but they're the only one who uses that entrance, or even a two-family house with a separate entrance and it's not going to be commonly used, then the tenant would be responsible for paying for that. And we are always able, again, to assess these issues and circumstances and what the legal obligations of the landlord are. Under fair housing laws, disability is considered anyone who has a physical or mental impairment that substantially limits a major life activity. Common examples you'll see there include both physical and mental and emotional disabilities are common issues that we see. And the hardest part with all of these accommodation and modification cases is figuring out what is actually considered reasonable. And so what is reasonable are changes under the law is considered any changes that don't impose an undue financial and administrative burden or would fundamentally alter the housing provider's operations. So what does that mean? Undue burden is, not a clear term. It is about as unclear as reasonable. So we have to look at different factors to determine what's considered undue. And it takes into account what the financial resources are of the housing provider, what the actual cost is of the request, how does it benefit the individual, and are there other alternative options? Or if it would fundamentally change how the housing provider operates, then that would also be considered perhaps not a reasonable request. And there are a lot of reasons. I'll just note we hear housing providers claim a lot of things that are not reasonable or not reasonable justifications for denying an accommodation or modification. And some common ones we hear might include that it wouldn't be fair to other tenants, or if we give this accommodation to one tenant, then everyone will want one. And those are not legitimate reasons for, and not sufficient reasons for denying the accommodation or modification that the individual with disability needs. Pause for a moment to take a drink. I'm sorry. Moment. All right, keep going. If an individual is requesting an accommodation or modification, if their disability is obvious, for example, they use a wheelchair, the landlord does not need to ask and should not ask for any verification of that person's disability. But if it's not obvious, such as the individual suffers from anxiety, then they should be prepared to provide information to their landlord from a third party that verifies that they meet the Fair Housing Act's definition of disability, that describes what the accommodation or modification is, and that shows the relationship between the disability and the need for the accommodation and modification. We actually have a template available on our website that you can use to bring to a medical provider that will help get the right information to your housing provider without revealing anything more than you need to reveal. A housing provider shouldn't be asking about what the specific diagnosis is, and you don't have to tell them what the specific diagnosis is, just have to explain how the accommodation relates to your disability. Sometimes it ends up, it can be difficult to show that relationship or explain it without actually revealing what the disability is. And the verification does not have to be from a doctor. Best practice is something that from professional, somebody with a professional background in the treatment of that disability or medical. So it could be a licensed social worker, and it should be somebody that is familiar with that individual, perhaps has been seeing them for a little while, or has some familiarity. There may be circumstances where that's not possible. Perhaps someone is changing doctors. Perhaps they haven't had treatment or been getting treated for very long for that disability, and it's not required that they have that history, but it is helpful if they do. A housing provider also can't place excessive restrictions as a condition of granting the accommodation or modification. That includes breed restrictions and size restrictions for assistance animals, whether they be a service animal or emotional support animal. Also, a housing provider can't charge additional fees as a condition of granting the accommodation or modification, including pet fees and pet deposits, parking fees, transfer fees, and they can't reword the fee and call it something different like an administrative fee. In addition, if a housing provider causes excessive delays in granting the accommodation or modification, that is also a violation of the law. Okay, I think I got through all of the fair housing stuff I wanted to talk about. You know, I will say this is definitely something where we continue to see a lot of accommodation or modification cases right now. We have cases, for example, of individuals who are, we have a case, a new case right now with an individual who is blind, who housing provider who is a subsidized housing provider, a federally subsidized housing provider, refusing to provide documents in Braille, for example. Or a housing provider who is telling all tenants that they cannot have visitors. And yet we have a tenant with a disability who has family members that help them with everyday tasks. And yet they're being told that even those family members can't come over due to COVID, that they can't have any types of visitors at all. And so that is another accommodation case that we're seeing that is an issue. Another case we have recently is we have a property where they've been doing renovations, and there previously used to be a lift to allow tenants with, it was they call a lift elevator, where it moved the tenants like a platform lift. And the housing provider in their renovations removed that and put in a chairlift. And now we have tenants who actually can't access their apartment, tenants who are wheelchair users who can't get in and out of their apartment. So sometimes it might be that things were okay with the property, but maybe there were changes at the property that then they need accommodations or modifications to address in the future. Okay, and if anyone has any questions on any of that, feel free to put it in the Q&A, and I'm happy to address them. And I'll leave certainly some time at the end for questions and discussion. And I will say, one of the concerns that we have right now too is that, you know, right now we have all these eviction moratoriums in place. But at some point, those eviction moratoriums are going to be lifted. And I think at that time, we're going to see a lot of people starting to move. And it's possible the rental market might get really competitive. And in those circumstances, we may see a lot more discrimination, where housing providers can take advantage of that and take advantage of people's kind of desperation to find a new apartment, and engage in illegal discriminatory practices. So it's certainly something we are concerned is going to happen, and expect may happen in the coming months, if and when things are, opening up in terms of the housing market. In terms of, we also are seeing, while there's not a lot going on, as much going on in the rental market right now, in real estate sales, there is a ton of, the real estate sales market in central New York is really hot. Essentially, there are very few properties for sale. Properties are selling very quickly when they do get listed, and that creates some tension and in the rental market as well, because there's just not a lot of options for people who are trying to move into home ownership. So they're staying in rental options longer, which means there's going to be less, perhaps less supply of rental housing just generally. Okay, on to eviction moratoriums. So there are several eviction moratoriums in place that impact people in central New York right now, and including the national eviction moratorium as well as a statewide eviction moratorium. So I'm going to talk about the national eviction moratorium first. Although some of it, as I explain, some of it doesn't quite apply because the state eviction moratorium is more expansive. So there is a national eviction moratorium in place that was issued by the CDC starting in September, which declares again, national moratorium on all residential evictions for eligible renters for non-payment of rent or non-payment of other fees or charges, and that is effective until December 31st. Under the national eviction moratorium, tenants still can be evicted for conducting criminal activity, threatening the health or safety of other residents, damaging the property, violating local codes or health ordinances related to health and safety, and any other contractual obligation that they violate. The federal eviction moratorium does block all stages of an eviction, so it does block all phases of the eviction process, and it covers all types of rental housing. So not just traditional housing, also includes mobile homes or land in a mobile home park. Sorry, I'm skipping through too many pages here. There we go. All right, next. In order to be protected by this eviction moratorium, the individual has to qualify, they have to certify and provide a signed declaration stating that they are working to obtain any government assistance, or they've used their best effort to obtain government assistance for rent. They have to meet income requirements that are listed here. Excuse me. Okay, sorry about that. I think I threw my sneezing. They have to, if they're unable to pay the full rent, have to show that they're making, attempting to make housing payments. And it has to, again, be related to a loss of income, loss of hours or wages or layoff, or extraordinary out-of-pocket medical costs. They also have to certify that they would likely become homeless or need to live in a shelter or double up with somebody else if they were to be evicted. And they would still have to pay rent at the end of the moratorium. There is no, under both the federal eviction moratorium as well as state eviction moratorium, there is no rent forgiveness. And so there are, some proposals to cancel rent or allow for more rental forgiveness, but there is nothing in place now. So tenants must be prepared to pay any back rent or fees and penalties accumulated during the moratorium. Under the federal moratorium, if a landlord violates it, they may be subject to a fine of up to $100,000 or actually jail time. And I'll talk a little bit more about it, the illegal evictions in a few moments. Excuse me. The state eviction moratorium is also in place, and it's called the Tenant Safe Harbor Act. And I apologize, this extension announced earlier this week. It was actually earlier this month, or maybe actually the end of September now. That's how quickly time has been going by lately. Anyway, this extends the moratorium until January 1st. So just about one day after the federal moratorium ends. And it protects, the state moratorium protects tenants from eviction if they are suffering financial hardship during the COVID emergency. It also extends the protections of the Tenant Safe Harbor Act to any eviction warrants that existed prior to the start of the pandemic. So any evictions that started prior to the start of the pandemic, under the state, some of these state orders, the eviction would has to go before a judge and before they move forward. So even if an eviction had already started, that eviction cannot progress until the tenant has the ability to go before a judge. There has to be a hearing, and courts are still closed for eviction cases. So even an eviction that had started, the courts are closed as of now until January 1st for landlord-tenant court. A landlord can still file paperwork and a tenant can still file a response, but the courts, there are no hearings currently until January 1st. And I'll give you some, I'll give you some resources to contact as well in another slide in a few moments if you are facing an eviction. Landlords under the state eviction moratorium, landlords are prohibited from issuing any charges or fees for late rent. And tenants who are facing hardship can use their security deposits as payments. Of course, we are 8 months into this pandemic, so I'm not sure how many people have security deposits left that they could use if to help pay that rent. So I'm sure that, is of limited use as we continue to move forward. There is some funding available, or has been some funding available, both from New York State, as well as some federal funding, again, for rental assistance, as well as assistance for landlords. But there still is no additional funding from the initial funding that was provided at the beginning of the pandemic. And it looks like there is not going to be any additional funding, federal funding coming. As Congress is, the Senate has left, and there is no additional federal assistance coming. The Senate is in recess. So it's difficult, certainly for individuals. There are, again, I don't know the status of every municipality's rental assistance, but I'll provide the number for the county Department of Social Services as well to contact. And of course, there's always 211 as well to contact to identify what assistance may be available for tenants. Illegal evictions are a huge concern right now. So illegally evicting a tenant can result in criminal charges. If a landlord wants to evict a tenant, they have to go to court and get a warrant of eviction. That does not change because the courts are closed. They still have to go to court. And if a tenant is ordered to move by the court, is being evicted and ordered by a court, they have to be served by a law enforcement officer and still have to be given 14 days to move. We see illegal evictions happening in a few different ways. It could include locking a tenant out of their apartment or removing a tenant's door. I remember hearing about a case where a landlord poured super glue in the locks and so the tenant couldn't access the apartment. It could be maybe making things unlivable in the apartment, like shutting off the utilities, or just not refusing maintenance, refusing to maintain an apartment. A landlord still has a responsibility to maintain an apartment, even if the tenant is unable to pay the rent. Threatening tenants or threatening to forcefully remove a tenant. I've even heard instances where landlords say things like, we have a way of making these things happen, and implying physical threats against the tenant. You know, kind of breaking kneecaps stuff that is pretty crazy to hear. But we are hearing those types of threats. Or just removing the tenant's belongings from the property. If you are being illegally evicted, it is a crime to illegally evict a tenant. Call the police if you feel safe doing so. If the police refuse to act or say that it's a civil matter, tell them that you read the law recently. Again, if you feel safe doing so, and tell them that you read that the law recently changed and that it is a Class A misdemeanor to illegally evict a tenant, and tell them you want to investigate it. If they still refuse, you can ask for their name and badge number and ask to speak to a supervisor. If they still continue to refuse, contact an attorney, contact legal services for assistance. I know police departments are probably not enforcing this. I know particularly when you're looking at smaller towns as well, that they're not enforcing this as a criminal issue. Some resources that are available as well to help. Legal Services of Central New York provides eviction defense in Cayuga County. Their number is here. This is their legal helpline, and they can help address any questions, and if needed, provide legal representation to you for eviction defense. There's also a coronavirus hotline that New York State operates, New York State courts operate, as well as a great resource page at lawhelpny.org, a great resource page on coronavirus. Some of the documents are a little bit outdated, so make sure you check the dates on those documents, but there's a variety of resources there that help provide updates on what's happening with evictions and what's happening with the law. As I said, this is a constantly changing issue. There's new guidance and new orders out all the time. So the other thing you can always do is just call the court. If there's a question, call the court as well. And the Cayuga County Department of Social Services number is here as well if you need emergency housing assistance, or 211, of course, is always a resource. And of course, you have other resources available in Cayuga County, whether they be community action, home site, the city of Auburn. All these resources are available. I'm sure I'm forgetting some as well. Trying to think who else, but I'm drawing a blank. But anyway, all these resources are available and can be found to provide you assistance if you need. Okay. So 2019 seemed like a long time ago, but I want to just highlight briefly, there was a lot of changes in the law in 2019 that I think we're all tending to forget about as 2020, the immediacy of dealing with everything now. There was a lot of tenants' rights changes and updates to tenants' rights laws in 2019 that, particularly as people maybe start moving again, may come up. So just some reminders on what some of those things are. First, a landlord cannot charge application fees of more than $20. Under New York state law now, $20 for a background check is the maximum that they can charge. To raise the rent or non-renew a lease, a landlord has to get non-renew a lease, or for a month-to-month tenant, the requirements of notice have changed, and this was effective in October of 2019. that the amount of notice that a landlord has to give to tenants is now based on how long that they've lived there. It used to always be 30 days notice from the time from when the lease ended, or for a month-to-month tenant, 30 days notice from the day rent was due. It is now based on how long they've lived there. So to non-renew or end a month-to-month tenancy, a landlord has to give 30 days notice if they've lived there, for tenants lived there less than a year, 60 days notice if you've lived there between 1 and 2 years, and 90 days notice if you've lived there for 2 years or more. As I said, including month-to-month tenants, you get almost 3 months notice requirement if you've lived at the property more than 2 years. Few changes related to security deposits. A landlord cannot charge more than a month's rent for a security deposit. They also have to return the security deposit within 14 days or provide notice on why they aren't returning the deposit. A tenant should request an itemized list of damages if the landlord is refusing to return a security deposit or states that they're not going to return a security deposit. Again, they should be providing notice on why they aren't. But if they're not providing that notice or not giving sufficient detail, you should request an itemized list of those damages. And tenants have a right to do a walkthrough before move-in. And I apologize, I have to update this slide. Also, they have a right to do a walkthrough before they move out. So before they move out of the property as well, you can get a walkthrough with your landlord. Again, in the age of COVID, you can require that your landlord, and make sure your landlord is wearing a mask when they enter your property as well. Some general tips in protecting your rights. We always recommend to sign a lease for a property. A lease protects you, and I know sometimes people like the freedom of a month-to-month tenancy, but a lease does offer additional legal protections for an individual. Put any request in writing and ask for all responses in writing. And then keep copies of all that paperwork. This can include if you communicate with your landlord via text message or email, preserve those communications. So save those emails, don't delete them. And if you communicate with your landlord via text message and there's some issues starting to rise, whether it's, maintenance issues or harassment or lease violations you're being accused of, if there's issues starting to arise, take screenshots of those text messages to save them in case you switch phones or something happens and you lose all your text messages. Keep copies of it. And again, even if it's just a screenshot of a text message, it's really helpful to have that as evidence of what's been happening and what is happening with your landlord. Get receipts for all rent payments. It's actually a landlord's responsibility under the law, under the tenants' rights law, to provide receipts. I'm guessing they still probably all don't. So make sure you get receipts for those rent payments and keep those receipts. Even if it's, having an image, a photo of those receipts. Keep a log of your housing search. So when you're searching for housing, looking for an apartment, keep track of who you're contacting. We're actually going to have a sample log on our website soon. We're just finishing up the edits on that. But keep a log of who you're calling and what they're telling you. If you're having issues finding an apartment, because it's easy, and particularly if you're being discriminated against, it's really helpful for us to have a good record of what's happening. So what are they telling you? Who did you talk to? What did they say? Are they even calling you back? Because sometimes you might be calling a landlord and they might not be calling you back. That could be discriminatory. And it's possible they might not be calling you back because of something they're identifying with you related to a protected class. And even taking screenshots again of Craigslist ads. If you're calling about a property and it's something on Craigslist, take a screenshot of that ad, because that ad may not stay up. And so having a record of what that ad is really helpful for evidence in a possible fair housing case. Take photos of your apartment before you move in and after you move out, or as you're moving out. Take photos or a video and take it of everything. I once lost a part of my security deposit back when I was yeah, I would say younger and stupider. I didn't clean out my stove. Totally forgot, didn't even think about it. Cost me $50 to have my landlord come back in and clean my stove. So take photos of the inside of your stove, the inside of your fridge, look in closets, everything. Video walkthrough might even be easier, but open up doors, open up cabinets, make sure you're documenting all of the conditions of the property before you move in and after you move out, in case your landlord tries to keep your security deposit. And if you are being harassed either by your landlord, by a neighbor, or anyone else, you can, in New York State, you can record your interactions with that individual without their consent. So if, for example, every time you go to the laundry room, your neighbor comes and calls you names, or a maintenance person makes inappropriate comments to you, put your phone on record in your pocket next time you go to that laundry room or to the mailbox or wherever this is being happening. Or if it's someone outside your door, you can record those conversations, record those interactions without that other person knowing. And again, helps provide evidence of issues that are happening. All right, that is everything I have in terms of issues to present. I'll stop sharing. If there's any questions, I'm happy to take those. Turn my video on. If anybody has any questions, you can put those in the chat or in the Q&A. I'm happy to answer any issues, any questions you have. All right, I guess I covered everything. So if you have questions going forward, I will share the presentation with any of the attendees and make that available. If you have any questions, you can always contact our office. Our number is, I'll actually pull that, I will pull that back up real quick just so you have it. Where are we? All right, our phone number is there. You can also email us at info@cnyfairhousing.org. Again, info, @cnyfairhousing.org. In addition, there's a complaint form on our website that you can access. If you have a question or an inquiry, you could post that there as well. All right. Well, I will go ahead and wrap up then. Thank you all. I haven't double checked the agenda. I'm not sure, Sarah or Haley, if you want to jump on.
We are here. That is the end of our program today. Thank you so much, Sally. I really appreciate it. I just realized that my camera was closed. Sorry. Not that everybody wants to look at this, but so Haley just put up our contact information. If anybody has any other questions in relation to anything or in relation to Sally, feel free to send us those questions. We'll make sure that we get them to Sally and we get them answered for you. So Sally ended a little bit early, and that was really the end of our program. So we want to thank you all for joining us for today's webinar. Like I said, if you have any other questions, please feel free to contact us. We are going to be sending you an evaluation through email. Haley, are you going to link it as well? Okay. And Haley linked it in the chat, so you'll be receiving it both ways. We would appreciate it if you would complete that evaluation and provide us with your feedback for today's training. Upon completion of that evaluation, you will receive a link and a password to the virtual binder that we have available. If you have any problems accessing that, please feel free to give us a call or shoot us an email. We want to make sure that every tenant in this webinar has the opportunity to access that virtual binder. If you are one of the participants who will be receiving a copy of the every tenant's guide. I almost said landlord, sorry, every tenant's guide. We will be in contact with you soon on how you can pick that up. So on behalf of Arise, Cayuga Community Health Network, our sponsors and our presenters today, we thank you for joining us and have a great rest of your day. Bye.